Okay, good afternoon, everybody. Thanks for joining us. Greatly appreciate. We've had a lot of great successes this year. I think we've had 10 or 11 presentations, had anywhere from 200, 300, upwards of 400 people attend. If there's a way that you feel that we could make these presentations more valuable to you or the folks you work with, please let me know. Send us an email. Tammy's going to provide you with the contact information. If there are topics in particular that you'd like us to address next year, by all means, please let us know. And we also do these presentations, a lot of these presentations on different topics live, so if you'd like us to come on in to your local place of business and do a one-on-one or group presentation, always happy to oblige. Now, last month we had gotten about halfway through this presentation, and we were talking a little bit about Medicare, and we were talking about our MSAs and how we want to be prepared for the MSA and not get behind the 8 ball, because the response to the MSA is going to take 2 to 4 months. So the takeaway is to get that thing started as early as possible. Submit it to CMS even before the settlement is made. You're going to have a pretty good idea what the figures are, and far better to be able to have that, know the number for the MSA so that you can calculate better an appropriate settlement figure. What about if the applicant's counsel says, as settlement negotiations proceed, let's get this thing over with. I'll tell you what. We'll just agree to indemnify my client against CMS if there's an increase, and we'll just have the judge approve the C&R right now while we wait for CMS. The answer to that is no way, Jose. That'd be a blank check. You have no idea. We can guess, but oftentimes our guesses are wildly wrong in terms of determining what CMS will and will not approve. So absolutely, positively not. Send the applicant's attorney packing. Completing the settlement after the MSA approval, attach the MSA documents for the C&R, or to the C&R for the judge, and don't submit the C&R for the order approving before CMS approval, as I just suggested, because CMS may require more. The employer may be required to fund an MSA, even if it is unreasonable, if you end up getting the order approving first. And awaiting approval allows you to pull back out of the agreement. You know, if you assume that the CMS is going to be $50, you have a tentative agreement based upon that figure, and you find out it's going to be $250,000, and you find out it's going to be $250,000. Obviously, you're going to want to reevaluate that C&R figure. If you've already gotten an order approving, you're stuck. You're stuck. By the way, we've had lots and lots of trouble over the last 20 years with the federal government and CMS and all of this hocus pocus. When I started this 25 years ago, this was not an issue, and I'm sure there's a bunch of old dogs in the group here today, like me, who remember the good old days when we didn't worry about this. Well, it's going to get even worse. California is starting to get into the act. In fact, they've been into the act for the last 6 years, but nobody's making enough noise about it. The State Department of Healthcare Services is going to be seeking recovery for Medi-Cal costs incurred by the state for treatment provided to injured workers that should have been incurred by employers and insurance carriers. So how in the world, again, is the state going to figure out what we're doing and whether or not they should be seeking recovery from us? The DIR is authorized to give the claims information to the Department of Healthcare Services. So these are questions that we should be seeking, information we should be requesting at deposition to determine if there are such costs that have been incurred. Be careful. Now, there was a decision about 5 months ago, the Alvarenga decision, in which the order approving the C&R issued in March of 2016. The injured worker who was a beneficiary agreed to a lump settlement of $39,000 and included PD, attorney's fees, and costs. The net to the injured worker was just over $22,000. The MSA vendor said, wait a minute, you need $24,000 set aside. The judge told the employer approval wasn't necessary as long as the MSA was below this, because the MSA was below the CMS review threshold. That was wrong, because let's take a look at this. The set aside needed to be $24,000, but the net, or I'm sorry, the gross, the total of everything was far in excess of the $25,000. The employer, after getting the order approving, learned of this mistake and filed a petition to set aside for quote-unquote mutual mistake. Holding one from the WCAB, there was no mutual mistake. Employer, this was your mistake. Sure, you relied on the judge, but this was your mistake. CMS does not require review or submission of the MSAs, right? It's all voluntary. If you wanted to get be covered and be assured that you weren't going to be abused by the federal government, you should have waited. You should have awaited for approval. The second holding, thank goodness for the employer, there was good cause to set aside the C&R. The reason for that was the net settlement was inadequate to fund the MSA by nearly $2,000. The injured worker was not properly informed, said the WCAB, of the consequences to him when the CMS is not asked to approve an MSA. Note that he didn't say that the employer was not properly informed of the consequences when there was an approval. The WCAB doesn't care whether the employer has been properly informed. The WCAB is going to assume the employer, the TPA, and the carrier, and the defense attorney are all fully aware of the possible consequences. So in this particular situation, the employer simply won because because the WCAB was trying to protect the employee. All right, C&Rs and structured settlements. Presumably many of you have engaged in these. They can be a real win-win. The applicant gets more money, and the employer can save money by purchasing purchasing a structure rather than a lump sum. Some more highlights. They're used for large value cases. I have seen them done for relatively low number cases, or low value cases, but that's not typically the case. They're often funded via an annuity that pays a periodic tax-free, check it out, tax-free, that's a good advantage, benefit over the injured worker's lifetime or some other suitable period of time, normally over their lifetime. So here's how it works. You get a structure or annuity. It's through an insurance policy sold by a life insurance company. The middleman, and there's always a middleman, is the license broker who is doing this not out of the goodness of their own heart, but for a commission. The annuity pays the applicant. The applicant or the injured worker is known as the annuitant. Pays them a tax-free benefit periodically. Now, it could be every 2 weeks, every month, every 3 weeks, every 4 months, whatever. It's usually monthly, though. In fact, I don't think I've ever seen one that wasn't every month. The lump sum payments, so let's say they can get X amount every month. Pull out a number out of your head. Let's say it's $2,000. But they know when their 15-year-old turns 18 and wants to go to college, they're going to need more. So they can have predetermined times for lump sums for particular highlights during their lifetime. And this is all pre-planned when setting up the structure. Why does the injured worker like this? Well, they got the guaranteed number of payments for a number of years, regardless of whether they die. Contrast to a stipend award where once they're dead, so the funding dies with them. The benefits can be continued for a specified period with named beneficiaries. So it helps to plan for taking care of the spouse. It takes for helping to take care of the kids, both when the annuitant is alive and when they are dead. And it protects against inflation because you can factor in costs of living allowances into the payment schedule. What is the employer like? Well, there are a number of advantages to the employer as well. Protects against applicants' premature death. You paid $500,000 for an annuity and they die next week. Well, what would happen if in a C&R situation if that were the case? Well, you'd be out your $500,000. That's not the situation here. Because the employer can be a co-beneficiary. Now, this is something that needs to be negotiated during the settlement process, but it's something that can be included. What else does the employer like? Rated age life expectancy can be used. Let's say the applicant is 50 years old, but they're morbidly obese, they've got serious uncontrolled diabetes, and name a few more ailments. They're probably not going. If you look at the life expectancy charts, and it says under normal circumstances they're going to live to 80. Well, it's probably highly unlikely in this case. They may have, in all likelihood, projected another 10 years to go, and that can be used to get a huge discount when calculating the premiums that is. This is an interesting factor. If you've seen commercials or ads for companies that buy out settlement agreements, you know, they advertise to people who are being paid over a period of time, you know, $1,000 a month, and they ask, hey, would you like to get a lump sum so that you can pay off your bills or buy a boat or whatever. And oftentimes that's very attractive to people, but the problem is the annuity was structured exactly to avoid this kind of problem, to make sure that the injured worker would have a constant flow of funds for the specified period of time, in likelihood the length of his or her life, and perhaps for family purposes beyond that. So these companies that have this gimmick are not particularly appreciated by the WCAB, and for that reason, workers' comp structured settlements cannot be assigned to a third party for a lump sum payment. Once it's the injured workers and their families, it stays with the injured worker. That's under the Labor Code 4900. No claim for compensation is assignable before payment, meaning that unless and until they've actually received the check and cashed it, it can't be assigned to anybody else. The judge will review the C&R and will ask, what if the annuity company goes bankrupt? You know, if you've agreed to pay the applicant $2,000 a month for the next 60 months or 120 months, and the annuity company goes bankrupt next month, that's going to leave the injured worker high and dry, isn't it? Well, no, it's not, because the judge is probably going to guarantee that the employer guarantee the payments. Is that fair? Not necessarily, because you could end up paying twice. Pay the annuity company and then pay the injured worker. But can we avoid that problem? Can the employer insure against that? Absolutely. The work comp carrier buys an annuity from a California admitted A+ rated life insurance carrier, the primary carrier, and then purchases a low cost assignment to a second California admitted carrier. And I say it's going to be a low cost. The second is going to be low cost because it is. Remember, this second carrier is only ensuring that this A+ rated California admitted carrier, they're only ensuring that it won't go belly up. Now, yeah, I know 15 years ago we saw a lot of workers' compensation carriers going belly up, but we're still talking about that because that's such a strange situation. So that, again, that second is going to be relatively inexpensive. What if the first goes belly up and the second insurance company goes belly up? Well, at that point, the CEGA will step in. Oh, by the way, that's not necessarily true, or that is not true if the employer didn't buy an assignment. So if the employer only provided the first annuity and didn't get the second, and the initial employer goes belly up, then the employer is going to pay 2 times. CEGA is not going to step in and save the employer in that situation. So employers self-insured, use the same structure as for insured employers, including the assignments. There's 3 levels of protection. You've got the life insurance carrier, you've got the second or the assigned company, and you've got CEGA. Normally, but if they're self-insured, instead of CEGA, we're going to use the self-insured security fund. It's going to be exactly the same impact. And if we require any further information on it, they do have a .org website on that. All right. Evaluating future medical or treatment costs per settlement. Obviously, Uncle Sam can help us there, but for reserve purposes and other purposes, we need to be able to eyeball this ourselves. Do we have sufficient funds for a buyout? Is applicant or applicant's counsel making a demand, which of course we're going to call the ceiling because in all likelihood that's the highest number we'll ever have to pay? Is the demand within the reserves? If it's not, what's needed to increase the reserves? Should we be rejecting the demand and making a counteroffer? Should our counteroffer be just that, a counteroffer, or should it be a take it or leave it? We're not going to consider any other demands. Should we be going into the nickel and dime mode to get the settlement within the reserve amount? There's lots of questions, lots of methods for resolving this thing, lots of negotiation styles. There's fewer answers. I'm very good at asking questions, not all that good at answering questions. One of the first questions you want to consider is our professional relationship. Do the parties know each other? How well do you know applicant's attorney? Do you have a good working relationship with him or her? Do they have professional respect? And perhaps more importantly, are you dealing with a good, tough, well-respected applicant's attorney or a bottom feeder who's willing to sell their client out? We know there are both types out there, and we know that how to proceed. If you don't know what kind of applicant's attorney you're dealing with, ask other adjusters, ask other employers or attorneys, ask me. I'm always happy to help in terms of reputations with regards to doctors or lawyers or judges or what have you. We have lawyers throughout the state at every WCAB district office, so just send me an email or give me a call and I can make inquiries on your behalf. So this last point I believe is important. The applicant's attorney's style is going to influence most or all of your settlement negotiations. If you're dealing with an attorney who's a true blue believer and bleeds for their client, you're going to have a completely different style or approach than if you're dealing with an applicant's counsel who just churns and burns the files and wants to take $10,000 on every case. How else do we need to evaluate future medical treatment costs? Well, what are the costs of what are the costs that we're going to incur if the file remains open? What about the allocated cost? Is applicant likely to amend or petition for an increase of cost? Can you get a stipulated language limiting future medical treatment, which can be done, but can you do it in your particular case? What about life expectancy? How long are you really going to be on risk here? As I suggested earlier, we have life expectancy tables, but then we have actual likelihood of living X number of years when they're diabetic, morbidly obese, et cetera, What about if applicant is intransigent at this point? Absolutely, positively not, does not want to consider a C&R. How many times have we heard that? My client, you've offered a settlement figure. In fact, I agree, says applicant's counsel, that it's a reasonable settlement figure, but my client absolutely does not want a C&R. They want to keep their medical treatment open. What do you do then? Or you stipulated 1, 2, 3 years ago. What do you do then? Well, I think you always want to consider, you want to diary this thing and revisit 1, 2, 3, 4 years down the road, because I think there's a lot of situations in which suddenly applicants who absolutely positively did not want to C&R out their future medical care are more than happy to do so at a later time. One, they may have found out that they really don't need all that much treatment. Number two, they might find that they really hate UR-IMR, which if you've been through that process as an applicant, you can probably readily understand. They hate dealing with the quote-unquote employer doctors. They hate dealing with the insurance carrier. They hate dealing with the adjuster or the defense attorney. They hate dealing with their attorney. They may have new costs, kids' college funds, et cetera. A whole lot of things can happen after 1, 2, or 3 years that makes somebody who is absolutely positively against doing a C&R more more interested in doing so. So what do we do to establish the settlement parameters? What do we consider? First, our client's objectives. Do we need a quick settlement? Do they just need to shut this down right away? Do you want to, on the other hand, do some serious case development? Do you want a scorched earth policy? Making an example, such as the situation where we've got a plant closure case and we know we're going to have 300 applicants, and this is the first one. Do we want to set a precedent of giving away $20,000 and let everybody else know they can get $20,000? Or do you want to fight this thing tooth and nail and make that example for everybody else? What is your client's comfort with risk? Are they risk adverse? Are they willing to let the dice tumble? What about the math? What are your chances of success? I always ask my attorneys, when you're trying to evaluate a client file for the client, tell us what the worst case scenario is. Tell us what's the best case scenario. What is the most likely case scenario, and apply the probabilities to each. And please don't tell me 50-50, because almost nothing is. So it's a 90-10, 20-80, whatever, and do the math. And just by considering the probabilities will more than likely give us a great starting point as to how to proceed with the case. We've already talked about applicant's attorney, the churners and burners. What about your judge? It's good to know what their background is, whether they're a former defense attorney or applicant's attorney, whether they practiced at another WCAB district office and have moved, and what was their reputation there. Again, if you have a judge that you're new to, please give me a call, send me an email. I'll be happy to get you the lowdown on him or her. Of course, then we always have to consider the cards we have been dealt. If we've got to take nothing, if we've got to guarantee take nothing, let's go get the F&A. On the other hand, we want a pair of twos. Sure, we can pretend that we're being aggressive, but we may want to consider a settlement sometime before submitting to the thing for a final opinion. We talked about revisiting the C&R years later, and I think I identified all of these, almost all of these. Another reason we might want to revisit a C&R 1, 2, or 3, 4 years after settling the case via STIP or F&A is they have a new job, and so they have new medical insurance. All right. Other considerations, determining future medical costs, just about impossible, but nevertheless, and I'm going to explain why, but nevertheless, there's no reason we shouldn't be trying. First off, it's impossible to tell whether there's going to be a rising or lowering of treatment costs, but we can try to factor in, make educated guesses. For example, if it's a situation in which we've got a drug that's soon to become a generic, that we can predict a dramatic decrease. On the flip side, we know that generics oftentimes don't come down the pike as fast as we're going to expect them, and we have such examples as the EpiPen that starts off at $100 or $200 and 5 years later is $600. More expensive surgery. Oftentimes the surgeries become more advanced and more expensive, but oftentimes when they've been performed thousands and thousands of times, the ability to proceed with it becomes more expedited and more economical. Talked about generics and over-the-counters. Keeping up, changing, or scrapping utilization review. There is a case right now going up to the California Supreme Court, which the name of which escapes me right now, but deals with UR physicians perhaps being personally liable for things that go wrong in terms of utilization reviews, denial, or modification of a treatment request or RFA. If the Supreme Court agrees with the District Court of Appeal in this particular case, I think there's an excellent chance that IMR may go the way of the dodo. At this point, we're expecting to have costs dramatically decreased through the continued use of IMR. But if the Supreme Court changes things, we're going to see a skyrocketing of costs. And of course, we always have to have the concern of the applicant escaping IMR, et cetera, et cetera, et cetera. So in terms of determining future medical costs, all I can say really is best of luck with that. It really is a mission. It is a mission impossible. All right. You've worked the case through for the last 3 days, 3 months, 3 years, 3 decades, and you need authority because you think you've got your deal. And this discussion goes to defense attorneys, it goes to adjusters, it goes to supervisors, it goes to brokers. It's evenly applicable to all of us. How do we approach the person in authority? How do we approach the person above us to get that authority? And of course, it's essential to do so. In doing so, to know what the holder of the purse strings, the HPS, wants or needs. The holder of the purse strings. As a father of 5, I am the holder of the purse strings. Unfortunately, there's no money in that purse anymore. Do not assume that the HPS interests and desires mirrors yours. I think very often we project and we assume that folks above us, folks below us, folks that we're working next to, and more importantly, and most importantly in this situation, the HPS views the case, views the facts, views the law like we do, and that oftentimes that's not the case. It just leads to problems. So obviously your priorities are going to be, in all likelihood, number 1, close the file, 2, do it economically and expeditiously. But the HPS may want to close the file. They may want the case never closed. They may be wanting them to make an example of this particular injured worker or this particular attorney or the judge or even you if the politics of the situation have gone badly. There may be labor problems that they're facing. There may be tangentially related issues that we can't even possibly know about. You may never ever know about all the variables that go into the thinking of the HPS when assessing whether our settlement recommendation is appropriate and we should proceed with that. We may never know, but there's no chance we're going to know everything unless we really ask, and that's important. Why ask for the HPS's priorities? Well, so you can factor them into your work and give them consideration. If you think you want to get this thing closed as quickly as possible, and as I suggested earlier, they want to get this thing, keep this king open for 3 years and make case law with it, your suggestion to settle it cheaply is going to be not only fall on deaf ears, but probably anger them. And also you want to demonstrate that your interest comports with their needs. I just said this, so we will move right along. I've often, when I watch a presentation and see somebody flipping through PowerPoint slides that were in there, but they don't reference them, they just flip right by them. I think a couple of things. One, I think, wait a minute, you thought it was important enough to create the slide, and you don't now think it's important enough to show it to me? I kind of wonder what it is we're skipping over. And then my next thought is, hey, wait a minute. If we skip through these slides, that means we're going to get out of here earlier. That's got to be a good thing. So go with we're going to get out of here earlier. That's got to be a good thing. All right. The bad news. Your holder of the purse strings wants to make case law. Instead of getting accolades for recommending you settle this thing economically and expeditiously, you get called on the carpet. What happened? Well, we forgot to consider the HPS's desires. And now the HPS thinks, and correctly, you don't get it. And it's probably talked that to your supervisor or manager. Able to resolve the matter in accord with HPS's desires, wonderful. But if you can't, what are your options? First off, it's hard to turn a ship very quickly. It didn't work real well with the Titanic and the iceberg. So you need to educate, instruct, teach, school, tutor, and train the HPS as you're going along, slowly, subtly, continually, documenting all the while. You don't want to debate the HPS and tell them they're wrong or that they're stupid or what have you, obviously. But you might want to, over time, share with them your concerns, the pros and cons of each and every possible way of resolving the file. And do definitely keep the HPS updated. I've seen file reviews where the HPS was there and the adjuster was there and I was there and the HPS hadn't heard anything since the last file review 6 months ago and something dramatic had happened in the interim. HPSs are not happy when they see that. As I suggested earlier, it's best to get them up to speed with the best case scenario. Let them know you've been calling them from their input. Avoid surprises and avoid the suspicion that you're keeping them in the dark for some reason. Not only does it keep them up to speed and not suspicious of us, it also gives them time to talk to their quote-unquote people, because they may be answering. They may be in complete agreement with you that this should resolve expeditiously and economically, but their supervisor or their client or whomever may think otherwise, and they need the information from you to help turn their people around and to consider their options. And we all like to look good. Your HPS is going to want to look good to the folks to whom they answer. Definitely make them aware of any upcoming events, depositions, MSCs, trials, the times and dates, the likely options, and the worst case scenarios. Not a one-time only HPS. By that I mean you're dealing with a client for whom you represent on many files as an adjuster or an attorney or broker, what have you. You really want to get to know them via phone calls and lunches and dinners and birthday cards. This is not a kiss behind kind of thing. It's just really getting to the people you're going to work best with, the people that you understand best and that understand you. It helps you to remind them that you're on their side and that you are not the enemy. And sometimes, in this day and age, we I'm an old fart. I'm 53 years old, so excuse me if this is just old people talking. But I think emails are wonderful and voice messages are great, and texting is terrific. I use it every day, mostly for my kids. But to really develop a relationship, that can't be done through texting and email. You really need to be able to talk and interact. and that's how you build the trust. All right, using PD advisory ratings to settle. You need to, obviously in every case, you need to try to figure out what the PD value is, and how do you determine how much PD you're on the hook for? Well, the first way is to pull out your old PDRS. Some of you are old enough to remember the 1997 schedule, which was about impossible to do. And by the way, I should take this opportunity to mention that our billing and our rating and AMA guides analysis department is expert on 1997 ratings, in addition to 2005 and 2013. But if you've got an old 1997, not sure exactly where to go, because I know the DEU raters have not been trained on the 1997 old school system of PD for many years. So if you need assistance on that score, please look us up. So your options in terms of determining permanent disability: pull out your PDRS, figure out the DFEC or the modifier, the age, the occupational variant, and if you're doing a good job, you're finding 2, 3, 4 different options so that you can argue and negotiate with applicant's counsel. Ascertain whether the AMA guides was properly applied, and you've just shot 3 or 4 hours. The other option is to go to a rating MSC. You can have the rater provide an advisory rating that is not admissible, but it's advisory to the parties to give some idea as to what the WCAB may provide in terms of permanent disability. Of course, you have to hope the rater's correct and that the guides still have been properly applied. Raters have very little education in terms of the AMA guides, and under the Blackledge case, case that came down about a little less than 10 years ago now, that en banc decision pretty much said, hey, raters, just because you think the AMA guides have not properly been applied doesn't mean you're supposed to say anything. If you want your opinion, the judge is supposed to ask for it. So you, if you're relying on a rater, a DEU rater, a rating MSC, don't presume that they're going to be able to tell you whether the report is correct or incorrect. And it's probably incorrect. I'll give you some stats about that later, but about 80% of the time, the AMA guides-based reports we are seeing actually overstate the level of impairment and permanent disability involved. About 18% of the time, the doctors actually get it right, and about 2% of the time, the PD is actually understated. We see that, but rarely. And this is based on a review of reports, well over 10,000 reports over the last many years at our rating department. All right. So first option was to rate the thing yourself. Second option was to get a rating MSC. Third option is to retain a third party to determine whether the guides were properly applied or was properly applied, and if not, what additional information is needed, what changes need to be made, and what should be done. Should they ask for a supplemental? Should they attack the report, take the doctor's deposition, et cetera, and determine whether apportionment is legal, appropriate, and if not sufficient, what needs to be added to the report to make sure that that apportionment stands, because remember, that is a defense, and therefore it is our obligation to provide the evidence on that issue. The rating, of course, the rating MSC, as I suggested earlier, the purpose is to determine the amount and the existence of permanent disability via the formal issues. The problem, or informal DE rating, the problem is you don't, we've already indicated one of the problems is, and that is the DEU is not educated in the AMA guides, and are not asked to provide their opinion, or will not be providing their opinion on these in all likelihood unless the judge orders them to do so. The other problem with DEU rating MSCs is that you only get one if the only unresolved issues are PD and future medical care. So if you've got other issues on the back burner, in this case, you can't even get a rating MSC. And I think we all know that there are cases that you can settle within the first day, the first week, the first month, and the first 6 months of opening. Oftentimes we settle these things at the deposition if we have the right facts and figures before us. But clearly you're not going to have all of the issues other than PD and future medical care resolved in the first day, the first week, the first month, the first half year. So you're going to need another source of PD rating. Nevertheless, if you do want to go with a rating MSC, you need to file all rateable reports, and that includes the PTPs, the QMEs, the AMEs, anything that was not previously filed with the WCAB. File a DOR, and go ahead and get your DEU rating. One other little problem, everybody has to show up for this thing. And I'm just going to repeat what I said earlier. The DEU provides minimal, if any, analysis of the shortcomings of the doctor's use of the AMA guides. There's a fourth option, and I'm going to a third party or AMA Guide's professional input. I've got a very suspect recommendation. The rating department I really think the most highly of is this place called Bradford Barthel. Bradford Barthel. Well, enough of that. This is a chart of some of the rating we've done over 1 year. And I said earlier, well, you see these blue dots each represent a report that was rated and analyzed to determine whether the AMA guides were correct. Any blue dot that is on top of this red line represent a report that was actually accurate. If the blue dot is somewhere underneath the report, it means that the report overstated the level of permanent disability. And if the dot is above the red line, it means that the report actually understated the level of permanent disability. So we've got 80% or so underneath the line, meaning they overstated, about 2% on the line, meaning, 18% meaning they were correct, and 2% over the line, meaning that they were actually shortchanging the applicant a small amount of money. So you can see why it's important to get somebody, anybody, I have my recommendations, but anybody to analyze these things correctly to assure that the AMA guides have been properly applied. We've reviewed over 20,000 reports and have got virtually every doctor in the state reviewed. Speaking of which, I want you to take advantage of this. We maintain a dossier on all the doctors whose files or reports we've reviewed. It is not for publication, obviously, but if you've got somebody who's recommended, or you've got a strike at QME, or somebody's recommended an AME, or trying to learn something about a doctor in the work comp system, and you're not familiar with his or her name, please give me a call or send me an email. My contact information is in this presentation. Give me the name of the doctor, and I promise you, I can almost guarantee we'll have some information and background on that doctor and where his or her strengths lie, where their weaknesses lie, what kind of files they should and should absolutely not be dealing with. These are just some of the four folks who have had to sit in my presentations. See, you're not the only one who have to suffer through. Here's an example of a rating analysis we did a while back. Took it from 70% to 13%, had a 100% case go down to 12%, saved over $1.8 million. So you can see where these can, it's really important to do this. These are some more of my credentials. By the way, I was a reviewer, or am a reviewer on the AMA Guides 6th edition, and people often ask, so is the 6th edition any more accurate than the 5th edition? Because I know we've all had problems with the 5th edition. There's all sorts of mistakes and typos, etc. in the 5th edition. That's why they had to come up with the errata sheet that's in the back of your book, and even that doesn't cover all the mistakes. So people ask, well, did they fix the 6th edition? And I can honestly say they've done a better job. But when I first got my copy, the very first thing I looked up was, well, if your name's going to be in a book, wouldn't you look up your name? I'm no different. I looked it up, and there was my name, Don Barthel, and they spelled my name right, which is highly unusual, and I really appreciated it. But underneath everybody's name, they gave the information as to where this person was located, and I'm located in Sacramento, California. Turns out the AMA Guides does not know how to spell Sacramento. So if they're spelling Sacramento wrong, you can be pretty assured that the 6th edition is far from perfect. People also often ask, do you think we'll ever adopt the 6th edition in California? We still continue to use the 5th edition because that's what Labor Code Section 4660 says. It says, thou shalt use the AMA Guides 5th edition, no other edition. We've had the 6th edition for quite a while. There's been no inclination to adopt it, and it is more conservative and more difficult to game than the 5th edition, and I don't see any inclination from most of the players in the industry to allow less or decrease permanent disability awards. So I just don't foresee the 6th edition being taken. I got to tell you that this is kind of a fun one. I was listening to Judge Paige Levy a while back at a CAW convention, and she said, and I quote, "You may not want to rely on the DEU to provide your ratings." Something I agree with. Let me This is a cross-examination of a DEU rater. Now, the cross-examination questions from the DEU, from the B&B attorney, I've paraphrased or tried to make funny. The answers from the DEU rater are, I promise you, word for word, verbatim from the deposition transcript. So, what do you say, Madam Rater, says the B&B attorney. DEU rater says, quote, the B&B, the Bradford Barthel analysis appears accurate, but it is more complex than I'm trained to handle. Huh? What's that? What do you mean? Rater says, quote, I merely accept what the doctor says unless it's completely out of line, and I rate accordingly. Huh? B. Rater, send the Bradford and Barthel analysis to the doctor for his comments and correction. Well, that sounds like a great idea, but that gives you some idea as to how little training the DEU has on AMA guides, as I suggested earlier. All right. What about cross-examining the rater? We did a lot of that back when we were dealing with the 1997 schedule. And it is still an option. You can have a formal rating issues, and once it's served, you object, usually about the rater's interpretations of the judge's instructions. It happens within a week, and then you request the cross-ex, and you proceed. If there's nothing formal about it, the judge will probably run fast and loose with the rules once the DOR is filed and served on everybody, and the DEU rater is sworn in. But because the issues presented to DEU raters are largely deal with the judge's instructions, the judges already decided what the answer is. So it's not going to be an occupational variant. It's not going to be a work restriction. It's not going to be from the 1997 PDRs. It's not going to be about anything that we used to normally cross-examine the rater about. So cross-examining raters, those of us that did it old school, are probably part of a dying breed. I don't think there's going to be a lot more call for it. But nevertheless, you are absolutely entitled to cross-ex the rater. To hold otherwise would be a deprivation of due process. And there was one case in which the judge refused to allow a party to cross-ex the rater, and as a result, the WCAB annulled the award and remanded it back to the judge to allow that deposition or that cross-examination to proceed. All right, this simply states exactly what I said 2 seconds ago. All right, you've determined the report is wrong. Uncorrected, it rates a gajillion dollars. Correctly, applying the AMA guides, it rates peanuts. This is not unusual, by the way. What are your options? Well, you can ask for the doctor for a supplemental report. You can take his or her deposition. You can go to the DEU. It all kind of depends. Supplemental report, option number 1. If you're dealing with Dr. Friendly or Dr. Open-Minded or Dr. Reasonable and Logical, just send a nice short letter to the doctor saying, hey, what about X, Y, or Z? Have you considered this, that, or the other thing? Or what the AMA guides say you're supposed to combine here instead of adding. Could you please do that? Should be a problem. So it's the cheapest, most economical, and expeditious way of resolving the thing. But what if you're dealing with somebody else? Oh, by the way, so if you're dealing with Dr. Friendly, just take somebody's analysis, whoever's done your analysis, and Bradford and Barthel, send it to Dr. Friendly and use that for his outline. But if you're dealing with somebody else, Dr. Know-It-All, and we all know a Dr. Know-It-All or quack quack, at this point, what's a supplemental going to do? What if it's not a Dr. Know-It-All? It's somebody that you think is just entirely incompetent. We all know one of those in the industry, or one or more of these in the industry as well, quack quack. In these cases, what will a supplemental get you? Absolutely nothing. It's going to cost you more money. It's going to delay the resolution of the case, and it's going to give the doctor an opportunity to try to justify indefensible positions and to muddy the waters even further. So why incur this delay? Why incur these unnecessary expenses? Why give the doctor an opportunity to muddy the waters even more by way of a supplemental? In this situation, you want to take the doctor's deposition, not Dr. Friendly. Or if you do take Dr. Friendly's deposition instead of a supplemental, I don't know why, but cross-exam would be a sure bet. Dr. Know-It-All or Dr. Suspect, there's 2 potential results of the deposition. Either he agrees with this, or you lead the horse to water, and if he refuses to drink, he swims with the fishes. What does that mean? What I mean is the whole point of taking a doctor's deposition is, well, let me put this a different way. If you ever get a report from a doctor and you call your defense attorney and say, have you seen this report? Your defense attorney says, yeah, I've seen it. And you both concur that this thing, you hate it. You absolutely hate it. And you mention to the attorney, hey, how about we take the doctor's deposition? And your attorney says, no, I don't think we can change his mind. At that point, you need to tell your defense attorney, thank you very much, hang up, and then file a substitution of attorneys and give the file to a different attorney. And here's why. You don't take a doctor's deposition to change his or her mind. If you're going to change his or her mind with logic and reason, you're going to do it through a supplemental and not incur the cost of the court reporter and the doctor's time by the hour and attorney time, et cetera, et cetera. You'll just say, hey, doc, here's logic, reason, and here's logic and reason. Please apply the logic and reason and change your mind and correct the report. No. Whenever I take a doctor's deposition, changing their mind with logic and reason, I think we spend about 5% of the time doing that. And to the extent that it's successful, great, but I don't expect that. The rest of the time, at least 95% of the time, is once I've determined that this doctor is not going to play well with others, is not going to change the report, and is going to continue to try to do my client in by providing too much impairment PD and or too little apportionment, then the objective is to do the doctor in to quote-unquote make him look stupid. And I do mean that, to make the doctor look stupid. Why would I be mean and want to make a doctor look stupid? Well, technically, what I want to do is make clear that the report's not considered substantial evidence. And if it's ruled insubstantial evidence, it's a report upon which the WCAB, WCJ cannot rely. So that's the objective there. And we've had situations like this. We had a pro per panel, DC, chiropractor. I love this one. Uncorrected, the report showed 64% or $40,000. Corrected, we found it was 19%, or a difference of about $33,000. Wrote a supplemental to the doctor, to the chiropractor, and said, with all due respect, you're not a doctor. I'm thinking, so who's the doctor in this situation? At least I'm a Juris Doctorate. I've got a doctorate there. But anyway, didn't say that. And nevertheless, went to the DEU. This is back when the DEU, before the Blackledge decision came down, and got the DEU to take a look at our analysis. They took a look at our analysis. They took a look at the doctor's report, and they disagreed with the doctor. They said, no, it's not 64%. They also disagreed with us. They said it's not 19%. They said it's 22%. We said, okay, instead of $33,000, we'll save $31,000. Draft that C&R. Life is groovy. And it was approved. I expected problems with, because I mentioned earlier this was a pro per, by demonstrating to the judge via the analysis that this was the proper way of applying the guides. The judge had actually no questions whatsoever. And you know what? It also helped to educate the applicant to the extent that the applicant could understand an analysis on using the AMA guides. What other uses can you? What other ways can you use a AMA guides analysis? Well, to educate the judge when you're walking through the C&R, educate the DEU, as we just did, educate applicants counsel. You're down at the MSC, and applicants counsel is demanding X, and you're offering X minus Y. It's really nice to be able to show them a points and authorities or an analysis that can be utilized as a points and authorities, because some of these analyses are 2, 3, 4, 5, 6, 7, 8, 9, 12 pages long. It's nice to be able to send a warning shot to applicant's attorney, hey, listen, you can either accept our settlement figure or you can go home and spend a week working on your own points and authorities. Faced with that situation, I think there are a lot of applicant's attorneys who start seeing the wisdom of considering strongly your settlement offer. And of course, these DEU and rather these AMA analyses are very, very, very helpful for doctor depositions. In fact, although I founded the service, I don't do the rating. We have people who do it far more than I do it, who do it every single day. And everywhere I take a doctor's deposition, I have them develop an analysis for me. Monday morning quarterbacking. There's been a lot of complaints about third parties doing analyses, AMA-based analyses. The California Society of Industrial Medicine and Surgery, CSIMs, you probably dealt with them, at one point complained to the Division of Workers' Compensation and said, you know what do we have to deal with these people? Why do we have to deal with some non-official permanent disability system? I mean, this is not the DEU we're dealing with. This is not a medical legal provider. This is not a PTP physician. Why do we have to deal with some third party? And the state of California had a response for these physicians that I don't think they greatly appreciated. They weren't sympathetic at all. Susan Gard, who was at that point the DWC spokesperson, said, the simple answer is we don't think we have authority to prohibit this defense strategy. If a secondary evaluation shows problems in the AME's or QME's report, that's something that the defense should correct. If the purpose is to get an accurate report corrected, the defense should do exactly that. It's the right of the insurers to look for evidence that strengthens their case. All right. I think we're running up. We've got about 5 minutes. I want to hit one last topic. If you're dealing with an applicant's attorney who's naughty, they can get in trouble because the judge can discipline them. The judge and the WCAB can sanction them. They can issue costs, etc. They can also send them to the state bar, and the state bar will discipline us naughty attorneys. But a pro per is not subject to state bar discipline. So, but they're still not allowed to be naughty. What do you do with an applicant who's absolutely, and it's usually a pro per, or somebody who's gone through 2, 3, 4, 5, 6 applicants' attorneys, and everybody knows this guy or gal's reputation, and nobody's going to represent him or her again. Well, what are your options? Contempt for abusive or disobedient conduct under Labor Code Section 134. You've got bad faith actions, those frivolous or solely intended to cause unnecessarily delays under 5813. These are helpful, but we also want them to be not described or pronounced to be a vexatious litigant. A vexatious litigant. This is going to be one of those things that you see every 3, 4, 5 times a year when you've got one time every 3 or 4 or 5 years when you've got this absolutely crazy applicant. We know who they are. The one that writes letters to you that are 12 pages long, and 12-page letters to the judge, and 12-page letters to your defense attorney. These are the crazy ones. If you get them to be pronounced a vexatious litigant by the WCAB, they're no longer able to file documents unless they have an attorney without the presiding judge's permission. In other words, when they start sending you letters, sending you applications, sending you claim forms, sending you moving papers, sending you anything, and they're a vexatious litigant, they must go to the presiding judge, and you don't even need to bother to read their paperwork. Let's go over this very quickly. Some recent case stated a growing number of self-represented parties and lien claimants. This is also aimed at lien claimants, and I know my friends down in Southern California deal with this continually. Lien claimants repeatedly file petitions or other papers with the WCAB that not only fail to comply with the requirements set forth in the Labor Code and rules, but that have no effective purpose in moving their cases forward. Recognizing the impediment to expeditious justice and the burden to the WCAB and other parties presented by those repetitive, meritless, and ineffectual filings, the WCAB proposed a rule for declaring vexatious litigants in workers' compensation proceedings, and we have those rules. According to the final statement of the reasons, quote, there is a compelling need for a vexatious litigation rule for workers' compensation problems or proceedings to address the problem of self-represented injured workers, lien claimants, and others who persistently or obsessively, and I think with the injured workers it's an obsession thing, obsessively attempt to relitigate an issue of law or fact that has been finally determined against them. As in civil courts, these vexatious litigants unreasonably or frivolously tie up the time and resources of the WCAB, thus delaying the cases of other litigants, and they impose a serious financial burden on the unfortunate objects of their attacks, that is us, and therefore there is need to restrain their misuse of the system. So, what's our definition? A party or lien claimant who, while acting pro per, that is without an attorney, repeatedly relitigates or attempts to relitigate an issue or law of fact that has been finally determined against them, and that's by the WCAB or the DCA. Finally determined means there's no other way to appeal this thing. Either they've done all the appealing they can possibly do, they've gone up to the Supreme Court, or they've missed the statute of limitations for appealing, and that's all expired. So there's no way to take this case any further other than to try to relitigate an issue that's already dead and gone. Number two, while still pro per, they repeatedly file unmeritorious motions, basically BS motions, pleadings, etc., repeatedly conducts or attempts to conduct unnecessary discovery, or repeatedly engages in bad faith tactics. I'm sure you have seen this. Three, has previously been declared a vexatious litigant by any state or federal court of record. So if they have a record elsewhere, you can use that against them. All right, here's an example of this. We had a pro per filed multiple petitions to reopen an award, even though the statute of limitations had already run, and there was no way he could win this issue. Filed various petitions saying the employer had committed fraud. I think you've all had one or two crazy claimants who claim that you were fraudulent, the judge was fraudulent, the doctors were fraudulent, the employer was fraudulent. This is one of those characters. Said that everybody was illegal, outrageous. Even the judge was doing illegal, outrageous things. And it was held, you know what? You're a vexatious litigant. Now, we've got lots of examples here, and these are going to be in the PowerPoint presentation that you have available on the website. You can either download it or print it up whatsoever, but these are just a few more examples of cases that have found the very same thing. So if you're interested in having somebody declared to be a vexatious litigant, here are some of the citations that you or your attorney should be considering. What's the procedure? Any party may initiate the proceedings. You simply file a petition citing the reasons why the applicant or the lien claimant or whomever should be declared a vexatious litigant, and include the supporting evidence. If a hearing was requested, the PJ or the judge has the discretion, I love this, has the discretion to take and consider oral evidence, take and consider documentary evidence, or take and consider solely documentary evidence. I assume it's number 3 that they're always going to take, because they just don't want to hear from this purported vexatious litigant again. So it's like, you know, virtually all cases, they handle it solely via documentary evidence. That's the point being, they don't have a right, even though the vexatious litigant or soon to be declared vexatious litigant is going to claim they have a right, and they'll miss out on due process if they don't. They're not given this right to make oral argument. That's not true. Opportunity to be heard only requires party to have an opportunity to file a written answer. All right. Well, I think we're just about done. We've got about 5 more minutes, but that's a little. That take us too far into your afternoon, so I apologize for that. Tammy's going to jump on in and provide you a little bit more information, so don't hang up right away. Hey, it's the beginning of the holiday season. We'll see you all in January after Thanksgiving and Christmas and the holidays. I'm sure I'll be weighing at least 10 pounds more. Here's Tammy. Happy holidays to everybody.